Good afternoon, everyone. Most of you will know me as Dr. Mark Fleer from Queen's University Belfast, and along with Clayton O'Neill, Dr. O'Neill, I teach medical law and ethics within the law school at Queen's. What we've tried to do this year is integrate as far as possible the health law and ethics seminar series into the syllabi for medical law and ethics, both at undergraduate and postgraduate level. And I'm delighted, I think, well, more than delighted, we're actually honoured to have Sir Jonathan Montgomery, no less, Professor of Healthcare Law based at UCL, that's University College London. Here today to present on the following, which is Montgomery. That's a famous case that many of you students will be becoming acquainted with. And Jonathan asks, evolution or revolution in the law of informed consent in light of that case. So without further ado, I'll pass over to Jonathan. Thanks so much.
Thanks so much, Mark. And perhaps you could give me the next slide, please. So there's no relation, Montgomery, nothing to do with me. This is a United Kingdom Supreme Court decision in 2015 involving allegations of failure to adequately counsel a mother during her late stage of her pregnancy. And she, in the end, had a son with significant disabilities and requiring significant financial compensation in order to support him. In that case, a new test for disclosure requirements was set out, and this is in paragraph 87 of the Supreme Court's judgment. And this is now what we are working on as the key starting point for whether or not health professionals have adequately explained to patients the options that they have, the risks involved in those options. And the key things about this test that are thought to be potentially revolutionary are that it's become a patient standard test. So this is based on a reasonable person in the patient's position and whether they would be likely to attach significance to any particular risks, with a slight gloss that occasionally we might know something about the particular patients, which mean that even if a reasonable person wouldn't think this was a material risk, a significant risk, then this patient would, and therefore it should be shared with them. So the first sort of key thing about this, which is potentially revolutionary, is that it moves to a reasonable patient test for whether risks are regarded as material. And it's thought that that's a revolution because the previous leading case, the case I'll talk about a bit later on, Sidway in 1985 from the House of Lords, set out a reasonable doctor disclosure test. So we've flipped from looking over the shoulder of the doctor in Sidway to looking over the shoulder of the patient in Montgomery. The second potentially revolutionary element of this test is that it isn't focused solely on the recommended treatment, the one that the doctor thinks is appropriate, but it also should include reasonable alternatives or variant treatments. Whereas previously the expectation had been that the clinicians established what the best treatment in their views was, and then they offered it to patients, explained it to them using a reasonable doctor disclosure, and then patients decided whether or not to accept the advice that they're given that this is the appropriate treatment. So we've done two potential revolutionary twists. We've flipped from looking over the shoulder of the doctor to looking over the shoulder of the patient, from a professional standards test to a patient standards test. And secondly, we've moved more broadly from a treatment selection to a range of treatments that not this clinician, but other clinicians might think are reasonable alternatives. So this decision came out in 2015. And if I could have the next slide, please, there's been extensive discussion of its implications. And the reference to this systematic review, and the idea of systematic reviews is in itself interesting, I think, in the context of legal materials, found that there were widely different views on whether or not Montgomery was a revolutionary case or an evolutionary case. So some people felt that it was a natural development of legal doctrine. So the argument there would be that we knew already that information should be disclosed if a responsible body of opinion expects to be disclosed, and that responsible medical opinion was influenced by the ethics of informed consent, and therefore whereas it might have been possible to withhold a piece of information in 1985, by the time we get to 2015, responsible practice required much more disclosure of side effects, risks, and options. So on that sort of analysis, the formulation in Montgomery is just the natural development of a professional standards test that is simply elaborating the thinking that has been going on. And it can also be argued that there's some key legal case steps, and I'll talk to some of them in a moment, which showed that this had been going on over some time. The revolutionary argument was that the law was stuck in a professional standards test because of the leading case of Sidaway, and Montgomery blew that out of the water and got rid of a deferential approach that it was alleged that the judiciary had towards medicine. And Lady Hale is said to be particularly proud of the Montgomery decision as being one of the most important things that she thinks she has done in terms of breaking the stranglehold of medical law in the hands of doctors. So these wildly different views appear in the literature. There's a view that says that we were already where Montgomery did, and all it did was articulate something that the law had reached. And there's a view that says that Montgomery is a brave new formulation, which is telling doctors now what's expected of them. There was a second sort of split of people. If you believe that Montgomery is an evolutionary articulation of the principle, then it becomes arguably a rather insignificant case. But people have said that that underplays the importance of showing that law and medical ethics are genuinely aligned, and the symbolic impact of reinforcing the direction of travel that medical ethics was taking is in itself a useful intervention. And others have argued that, well, making something a legal standard rather than a professional standard is important because it brings into play different sanctions. That seems to be a view that assumes that the sanctions applied by law are somehow stronger than the sanctions applied by professional disciplinary bodies. But if you're an individual doctor, you probably see that rather differently. If your employer loses a malpractice case, then you're not going to be personally out of pocket. Your insurer or your employer is going to carry the financial can. If you get full foul of your professional disciplinary body, then you might lose your livelihood. So lawyers tend to think that it's terribly important to do things through legal mechanisms. Clinicians tend to think the bigger impact comes from professional discipline and norms. So there's another divergence there that asks us to what extent we should think that the Montgomery decision is a big deal. And the third divergence of views that the researchers found when they interviewed people about what they thought the impact of the Montgomery decision was raised some interesting questions, which in the literature is sometimes described as who's in charge. Is it law or medicine? So if you think that Montgomery is a revolutionary decision and you now expect the medical profession to fall into line behind it and do things differently, then you're going to think that the law is a crucial driver for change and improving the service that patients get. If, on the other hand, you think that Montgomery is essentially evolutionary, and particularly if you think it's evolutionary by catching up with what medicine is doing, then you're likely to think that the law is lagging behind, and maybe what it's doing is catching up with something that doctors have thought already. And it's very typical in areas of new technologies and advances to argue that law is constantly catching up with medical advances. So this may have a broader significance than just the area of informed consent. So faced with this understanding that people look at the same text or same summary, a summary of the same text, and have these wildly different views over it, I wanted to do some thinking on how we would decide which of these views was more appropriate. So what I'm going to share with you now is some early thinking, and I've been trying to trace through the development avoiding it being revolution or evolution at this stage, of informed consent, law and commentary. And the next slide has what's probably the earliest reported case is discussed in the literature, Hatcher and Black. This is a decision of Lord Denning. This was what's sometimes called a white lie case, somewhere where the patient asked a question and the doctor thought it was better if she didn't have the answer. It went to a jury because in those days medical malpractice cases went before juries, and Lord Denning advised the jury, and we only really have the Times reports of these, so it's a bit difficult to be quite clear whether the journalists got it right. Advised the jury they should only find the doctor guilty if he'd fallen short of the standard of reasonable medical care, and was therefore deserving of censure, disapproval. Now, a few years after that, if I can have the next slide, the first of the English books on medical negligence came out, authored by Lord Nathan. This was just before the decision in the case called Bolam, which is a matter of great controversy as being the origin of a deferential approach. Bolam decided in 1957, but this book was completed late in 1956. Bolam decided that the key test for negligence was whether people had complied with a practice accepted as proper by a responsible body of opinion, which has become seen by commentators as essentially allowing doctors to set their own standards. But before the Bolam case was decided, Lord Nathan had made an attempt to explain what the law of informed consent, as we would now call it, was. And he says, ordinarily, the patient's entitled to have his questions answered fully and accurately, to have explained to him the various factors to which consideration ought to be given in exercising a choice as to the form of treatment to be undergone. He thought there wasn't any duty to warn of inherent risks that were there with any form of medical treatment, but there was a clear duty to warn patients when there were special risks known to medical men, but probably unknown to the patient. And in these days, we always talked about men in clinical posts. And in particular, Lord Nathan thought that electroconvulsive therapy, which was the subject of the Bolam test case that I mentioned, was a special risk category. So he thought there was a clear duty to warn patients of the risks. And then less than a year later, another jury direction was issued, which led to a doctor being acquitted for failing to tell the patient about the risks involved in electroconvulsive therapy. So it felt like when the court had a chance to actually look at it in Bolam, it had taken a step back from what the legal commentators thought was appropriate. And it wasn't just the Bolam case, which is interesting. As we move into the key House of Lords case of Sidaway, decided in 1985, we can see that in the commentary, people have pretty much ignored Bolam as we now understand it. So on the next slide, we have a couple of quotations, one from the British Medical Journal, one from a textbook on health services law, 1979 for the BMJ, which summarised the requirements of the law, that there would be a sufficiently full explanation of the nature, effect and risks of the proposed treatment. And where there's a choice between alternative courses of treatment, the patient should be told enough to make an informed choice. John Finch, in the book on health services law, the patient should get a full and comprehensible explanation of the treatment which is proposed. So these are in many ways quite like the Montgomery decision that we started. And then we had, if I have the next slide, the decision in Sidaway. Now, Sidaway has been interpreted by commentators more recently, by the Supreme Court in Montgomery, as having handed everything over to doctors. So Sidaway has been interpreted as an application of that Bolam test that I just summarised. But when you read the 4 speeches, there are 5 judges and 4 speeches in Sidaway, it's far from clear what the majority of the majority decision was if we were doing a little exercise in extracting the principles of the case from these 4 different judgments. So at summary level, Lord Diplock seems to go straightforwardly for saying it's a peer review standard. The question is, was what was said to the patient consistent with a practice accepted as proper by a responsible body of opinion? The second speech, Lord Bridge and Keith, so this counts as two, although it's one speech, Lord Keith concurred with it, explains that it's primarily bolum and explains some circumstances where it seems very obvious to the judges that risks are so important that they should be disclosed. Lord Templeman goes on a rather different track, doesn't discuss bolum at all, and uses a phrase of sufficient information for a balanced judgment. And Lord Scarman argues that what we should have is a prudent patient test, which is essentially the test I showed you from Montgomery, which he was articulating back in 1985. Now, if you look at the judicial interpretations subsequently, the clearest statement of the Court of Appeal in Gold against Haringey, which was just about 3 years after Sidaway, seemed to treat Diplock as if his was the only speech that you needed to read in the Sidaway case. And the understanding began to emerge that therefore what Sidaway did was to describe the disclosure requirement as driven by the bolum test and therefore driven by responsible medical practice. And that's led to us thinking that the law had in Sidaway handed everything over to doctors, hadn't told them what they should do and just accepted what they were already doing was enough to keep them off the hook. And on that basis, of course, you end up thinking that Montgomery is revolutionary. And actually, when you read the case law in between, it's quite mixed in terms of the way that it interprets it. But rather than taking you through all of that now, I want to look at a few extrajudicial statements from Scarman and a brief commentary. So on the next slide, you have the first two quotations from a talk that Lord Scarman, who was in the minority, we thought, as a prudent patient test in Sidaway, in a talk he gave at King's College, London. And he took that list that I took you through just now of the 4 speeches and said that, well, 3 of the majority, as he called it, and by this he means Lord Bridge, Lord Keith and Lord Templeman, recognised the existence of the right to know, but they held that there were circumstances in which the right to know could precedence over the duty of the doctor to do what I thought is best, but that it wasn't automatic. So it was a question of how you balanced it. So they agreed with what he described as the First Lord, or that's himself, that the right to know exists, that it could never be disregarded, and sometimes it might prevail. So what Lord Scarman has done is to create a majority of 4 in favour of the prudent patient test, albeit recognising that it might be not be the only thing to be taken into account. Whereas the Court of Appeal in Gold and Haringey had created a majority of 4 by adding together, 23 by adding together Lord Diplock, Lord Bridge and Lord Keith, saying that this is all about the bolum test. And when Scarman summarised in the same lecture, next slide please, where he thought the law had got to after Sidaway, he said it was that if there are no medical reasons which would operate against telling your patient something, you were obliged by law to give an explanation of the consequences, cons as well as pros. And he went on to say, I have little doubt that as the case law develops, as it will develop on the basis of Sidaway, the law will come to include the necessity of the doctor indicating the possibility of other treatment than that which he personally recommends, which you'll remember is one of the revolutionary elements that seems to be there in Montgomery. So why is this interesting and worth quoting here? Well, this suggests that Sidaway is revolutionary, that Sidaway is the point at which the right to know enters into English law and also predicts the development into the second revolutionary element, that it isn't just about the treatment doctors select, but it's also about the alternatives. An academic commentator, Simon Lee, then at King's, I think he came to you after that, if I remember rightly. Next slide, please. He argued again that Sidaway was revolutionary. It will become to be seen as a significant expansion of the ambit of informed consent. He says, I imagine ever since Sidaway, plaintiffs have been tacking onto claims of negligent treatment, claim they weren't in a position to give informed consent. Once those cases come to court, if not before, medical practice will alter to cover against such actions in the future. So here we have an argument that says not just that it's revolutionary, but also that it's driving change. Well, what seemed to happen then was the cases, most important of which was Gold and Haringey that we saw early on, seemed to retreat from that sort of interventionist approach. And instead what they do was focus on the fact that these are tricky decisions that doctors were best placed to decide, and that therefore we were aiming to reinforce good medical practice in our legal interventions. And that was a position that was happening across all of our malpractice law. So the Bolam test, although it emerged in a case that was partially about informed consent, was mainly being used in relation to general malpractice claims. Although interestingly, it only really started being used, if you look at the citation maps, in about 1979, 1980. So it wasn't that Bolam drove this, it was that something happened at the end of the 70s and the beginning of the 80s that adopted it as the go-to place. And that lasted for a while until people became increasingly unhappy with the idea that the law wasn't really regulating medicine so much as deferring to medicine. And in the main malpractice area, if I can have the next slide, please, case of Belitho introduced a gloss on the Bolam test saying that judges should check that there was some logical basis to the positions that medicine was taking. And in 1998, in PS against University Bristol Hospitals Trust, Lord Wolfe attempted to introduce into our law of informed consent the implications of Belitho. So this is his attempt to recast Bolam, or recast Sidaway, and it's Sidaway's use of Bolam to take into account this closer scrutiny of what clinical practice was doing and what expert evidence was said. And Lord Wolfe argued that the test now, incorporating the impact of Belitho, would be if there was a significant risk that could affect the judgment of a reasonable patient, then in the normal course, it's the responsibility of a doctor to inform the patient of that significant risk if the patient needs that information to determine for himself or herself what course he should adopt. Now, you would expect a Court of Appeal case bound by a House of Lords precedent on the test for disclosure to have some discussion about what impact it had on the decision. But that didn't seem to be very significant in the case. It's also interesting that although Lord Wolfe says this in PS, the actual disposition of the case was based on the fact that there was a responsible body of opinion who supported the non-disclosure of the risk, and for that reason the claim failed. But pretty much everybody, including myself, took this and put it in their textbooks to say, well, now we know what the law of informed consent is, and that was where we were until we came before the House of Lords in a case, which on the next slide, Chester against Afshar. Now, Chester against Afshar has never been cited on in terms of the application of a difficult, so it may have been cited and it hadn't been a couple of years ago when I last looked at this. It was a case primarily about causation, and it was in the course of it, all the judges assumed that there was some form of duty to warn, some form of consent requirement. Lord Bingham, perhaps the clearest statement, there's a duty to warn about small but unavoidable risks of serious adverse events. One of the reasons why there was no clear definition of what the meaning of the duty to warn was that it was actually conceded by the defendants that there had been a breach of the required standard of care, so there hadn't been compliance with the appropriate disclosure requirements. So it wasn't contested. It therefore wasn't argued what the right test was. But despite that, the Department of Health immediately picked up Chester and Afshar's duty to warn as the correct articulation of the rules and incorporated it in its guidance. This is Department of Health for England, so this is binding for England, but referred to elsewhere as there being now in the law a legal duty to warn. And Jose Miola, who I usually manage to quote for the opposite conclusion for this, wrote in his book on medical ethics and medical law, in his analysis of Chester, that this still left quite a long way to go to match the ethical standards that had by 1998 at least developed much clearer guidance on what was expected. So on the next slide is just a very thumbnail sketch of the early medical guidance. So back in the 1970s, the medical defence unions, which ensures doctors against being sued for medical malpractice, developed standard consent forms, which explain that proper explanations need to be given of the risks. In 1981, the British Medical Association produced a handbook of medical ethics, in which they picked up a test of adequate explanation to decide whether or not to accept advice. The GMC, the General Medical Council, the disciplinary body, barely touched on it until its 1998 guidance, in which it said for each option, explanations of likely benefits, probability of success, discussions of any serious or frequently occurring risks should be disclosed. And on the slide after this one, next slide please, the development of that to respond to the Montgomery decision says that paragraph 10, you must give patients the information they want or need to make a decision. They give them the potential benefits, risks of harm, uncertainties, likelihood of success for each option, including the option to take no action, which is broadly what it had already said in 1998 before the Montgomery decision. But they've added from Montgomery the importance of actually taking active steps to find out what matters to patients so that you can share benefits with them. So the evolutionary version here would say that Montgomery has really not changed what the medical ethics advice is. It's provided a gloss on it, but it's more than, it's just really reinforcing the position that the GMC had already reached. So if you can give me the next slide, which is my penultimate one. If we go back then to those sort of three questions, is it revolutionary or evolutionary? Well, revolution and evolution both feel a little bit too linear for the pattern that I've put in describing it. It's more like a sort of intertwined dance between medical ethics, legal commentary, and the judiciary's approach. The legal commentary started with something quite similar to where we've ended up. You could argue that the law took a wrong step, but you'd probably need to argue that in relation to the Court of Appeal's decision in Gold. It wasn't that Sidaway took a wrong step, but that it was possible to interpret Sidaway as having taken a wrong step. And we know that because the commentary I showed you briefly around Sidaway was able to talk it up to the opposite effect, to say that Sidaway was moving us very much towards right to know, right and entitlement to get the information that you need sort of approach. So if we're being more disciplined about our analysis of legal doctrine, I don't think either revolution or evolution quite fits the bill. But it's very interesting that when people were interviewed by this research team, what came across to me reading the piece they wrote about it was how little the people they were talking to actually knew about the English law informed consent and how it had developed. Similarly, in relation to the questions about whether it's symbolic or significant, whether it aligned law and medical ethics or whether it pulled them apart, there was significant ignorance about what actually was being said by the advisors to the medical profession. And what seemed to be happening was those who knew about medical ethics tend to assume that medical ethics already had got there, so this is of very little significance. Those who knew only about the law thought that the law was extremely important, and at the very least, it added to the strength of sanctions, as I mentioned earlier. And so when you get to the catch-up or driver for change argument, it seems to me that people just explained what they already expected to do, and they weren't really examining the reality of the dynamics of law reform. So I think it's a much more complex picture than people imagine, and that in itself is worrying, in much the same way as I think the way in which the Supreme Court analysed the factual circumstances, the applicable guidance in Montgomery itself is highly suspect. And my wife, who is a midwife, and I wrote a bit, which I haven't, a piece called Montgomery and Montgomery on Montgomery, and it's an inexpert decision, trying to pull out how unconvincing the Supreme Court's analysis is of what was going on. And we, of course, work primarily in the clinical ethics and context. So on my final slide, I just want to reflect on a few elements that we might learn from this exploration of whether Montgomery should be best understood as being evolutionary or revolutionary. And just do it through a lens of a few rule of law issues. So one which never really seems to be discussed, but is pretty important if you look at standard rule of law analysis, that you shouldn't have retrospective legislation. But the nature of the case law in this area is that it is legislating retrospectively if it is indeed revolutionary. So in Sidaway, decided in 1985, ruling on an operation carried out in 1974 by a surgeon who was dead by the time of the hearing, and in which Mrs. Sidaway lost her case essentially because she couldn't prove that the surgeon hadn't given her an explanation. But insofar as it established a new set of rules for informed consent, as Scarman and Simon Lee wanted to argue, it would be imposing something on a surgeon in 1984 that he couldn't possibly have known. In Montgomery, it's 16 years from the birth of the son to the ruling. If Montgomery truly is revolutionary, then how would Dr. McClellan, who delivered the baby, know what the law was going to be in 2015 when she was taken to in 1999? You can just about answer that problem by pointing out that the Pierce decision had been decided by that stage. So if she read her law reports appropriately, maybe that wasn't a retrospective decision, but it does raise some questions about whether you can really drive revolutionary change through judicially made law. Of course, we can easily answer that by taking the view that medical ethics and law were intertwined, because by 1998, the GMC was clearly telling Dr. McClellan what the test should be in terms that are substantially the same as Montgomery. Second rule of law issue, which I think is quite interesting from the brief history I've given you of decisions, is how little work is done by commentators and by judges on the rules of precedence that all students are taught to work with through their law degrees. I mean, we should have had careful discussions about how we created the ruling in the case, the ratio, the reason for the decisions, and distinguish that from observations that were made in the course of discussions. And we should have attempted to work out what the majority's meaning of Sidaway was. But what the Court of Appeal did in Gold was simply to read the first judgment and decide that that was the judgment. No student, of course, would ever read the first judgment in a series of three and then read the others less carefully, and nor would any of us academics, I'm sure. No, we did some of that in commentary early on, and then we sort of forgot about it. We particularly failed when we got to looking at Chester and Afshar, which was a decision of the House of Lords that should have been bound by a previous decision and let it explain the difference. And even in Montgomery, they don't really give a clear explanation of why it was acceptable in the laws of precedence to depart from an earlier House of Lords decision. Although they do explain why the world has become a different place and why their position is an appropriate one. And then we have what's often the classic formulation. I've taken a version of this from that same lecture from Lord Scarman, but you'd find it in many of the commentary which is worried about deference to the medical profession, that we should expect medical ethics to be formulated within the law and be subject to the rule of law. And we usually use that to justify judges telling doctors what the right things are to do. And we usually look at a case like Montgomery and its supposed revolutionary impact in order to demonstrate how we're doing the right thing. And we do that because we somehow think that the law is always progressive and moving things in the right direction. But if we were taking seriously the idea that medical ethics must be formulated within the law and be subject to the rule of law, and if the analysis in Montgomery of the reason why it was revolutionary because of the failures of Sidaway was correct, then isn't the implication of that was that it was improper for the General Medical Council to develop a patient-centred informed consent standard? Because surely if medical ethics was formulated within the law and subject to the rule of law, and that the legal rules at that stage were that the appropriate disclosure requirement was it must be accepted as proper by a responsible body of opinion, the Bolam test, as Gold decided, established in Sidaway, then it's wrong for medical ethics to move in what most of us on this call probably think are the right directions. So it seems that we appeal to the rule of law, and we like decisions that are sympathetic to our own liberal predispositions. And we tend to be very critical of medical ethics, which we dislike, and argue that it fails to appropriately honour the subjection of medicine to law. And maybe what we see from this, rather as I saw when I was reading that systematic review paper, interviewing people on their impressions, is that we learn much more about the values and attitudes of commentators than we do about the legal materials. And of course, that should worry us if we think that the rule of law partially depends on judges being value neutral and working on the values that the law requires of them, not their own personal opinions. So those are my thoughts on whether Montgomery is evolutionary or revolutionary. And it turns out to be much more complex than I thought. And I'd be very interesting to see what people made of that. And that's the end of my presentation. Thank you very much.
Thank you very much, Jonathan. That was really interesting. I have to say that I was worried I'd lose you a few times because of my own internet problems, but I was able to continue listening, so that was great. I was able to follow what you were saying. At this point, I'd like to open things up to questions. So if there are any questions from those present, if you could raise your hand and I shall try to identify you. If you prefer not to ask any question orally, if you prefer to write it down, then we've got a chat box or chat function available, and so feel free to use that. Type your question, or maybe it's a comment in the chat. But any questions then, please? Takes a while sometimes, doesn't it? Brilliant. Oh, it's Solvita Olsteiner. Solvita, I think we've met a few times, haven't we? I think I've got you right. But anyway, if it's not the right person, then you're coming on camera. It is you. Hello, Solvita. We met a few times.
Hello.
How are you doing?
Thank you so much. How are you doing? And I'm very, very glad to meet Jonathan. We met some long time ago.
Nice to see you again.
And Mark as well. Yeah.
Great. So over to you, Solvita.
Thank you so much. I was really listening with great interest. But Jonathan, I would very much wish to ask you about your last slide where you cited Mr. Carmen saying that medical ethics must be formulated within the law and are subject to the rule of law. And this is, of course, particularity of case law countries. And I'm coming from Riga, and we have a different system. However, I would like to ask you how, and if you have some ideas, how the rules of medical ethics should be formulated, and who is supposed to do in order to comply with the rule of law principle.
Thanks,
Since
Ravita.
you were so much about this, you probably have an idea of this. Thank you so much.
So the point I really wanted to make in the presentation, before I answer your question, which I will answer, is that we need to be paying more attention to this, particularly in the common law countries, because we allow it to glibly slip off our tongues, saying, of course, medicine must be subject to law, but actually we don't think very much about the extent to which our judges also have obligations under the rule of law. But the actual answer, I think, is one which we've got a pretty good solution to in practice now in the UK. And that solution is that our norms are articulated in professional guidance sponsored by the General Medical Council, and the process by which they are produced is now a deliberative process. So back in 1998, when the documents we were talking about were produced, then it would have been produced by a committee of doctors with maybe a few tame lawyers, people like me, who would be on it, who would talk about it, and maybe someone who was trained in ethics. Now what they do is that they review existing guidance. They have a legal commentary on it from their in-house team to look and see whether it's consistent with legal standards. They seek counsel's opinion if there is ambiguity. So they specifically go out and ask to ensure that the guidance is consistent with the legal frameworks. They also monitor the concerns that come into the General Medical Council. So they can come from patient complaints. They can come in from requests from doctors for advice where they're not sure what's expected of them. And then having pulled those things together to identify what they think might be plausible ways of developing the guidance, they engage in public deliberation. That public deliberation includes publishing consultations, which enable people to have a look and comment on, but they also do sort of citizens jury crime work. So they go out and they create scenarios and they find out what the public thinks the issues are and how they might resolve them. And they also work on identifying groups whose voices may not have been heard in that process. So I wasn't involved in the guidance that the GMC produced on consent post Montgomery, but I chaired a task and finish group that produced the guidance that they issued on confidentiality. So we identified, for example, that there were particular issues around confidentiality for people with impaired capacity in nursing homes and also in relation to vulnerable groups such as people who were subject to human trafficking. So there's now quite a careful deliberative process that tries to make sure that something issued by the General Medical Council under its statutory duty to issue advice to the medical profession is not anymore just a medical view. It's now a public view, and into that is incorporated a consistency review with the law. So that feels to me quite a good model. It's quite a labour-intensive model, but it bridges the gap between a judge who only gets to see a very difficult case in front of her and the risk coming that their assessment is skewed by the specifics of a very difficult case as opposed to generality. It avoids that problem. It avoids the problem that Parliament doesn't usually make time for these sorts of things, and it also avoids the problem that we can't allow medical ethics to be a self-referring enclave. It has a public responsibility that's there. So that feels to me an appropriate response. It does mean that the meaning of law in my concept of the rule of law is broader than a decision of a judge or a statute passed by Parliament. It's a norm creation process, and I've, as you probably know, written at great length about trying to explain how that operates, and I sort of stand by that view. I think it avoids falling into this trap that when we say medical ethics must be formulated within the law, we only really mean that when it's the medical ethics that we like, and you can't really derive that just from the law. It has to have other roots as well. I hope that answers the question, responds to it anyway.
Thank you so much. Yes, this very much responds, and of course you were very rightly pointing out that there was substantial change in procedures and of course and the way how we get these ethical codes, and I even coming from Latvia, I really highly value GMC ethical codes, and I see this, and this is of course our achievements last 20 years. Which was, and it's, thank you so much for the answer.
So what is quite interesting now, Savita, and if you haven't found it, if you drop me an email, I'll help you find it on the website. The GMC now publishes the public engagement reports. So it publishes the reports of the citizens' deliberations. So you can understand the foundations from which these developments occur, which is a really good, it's not as transparent as it could be because you have to know it's there to find it. But it is based on open deliberative work, and I don't think it's fair, therefore, to accuse the medical profession of simply being judging its own course. It tries really hard to avoid that.
Lovely, thank you so much. So I think hopefully you can hear me okay. Sorry, the screen.
Yeah, we can hear you.
Fantastic, thank you. There was something of a dialogue there, and that was interesting to hear. It's great when we have one of those in this sort of setting. But I was wondering, Jonathan, unless I might have misheard, and that's partly because of my technical difficulties today, but I think you described something of a trialogue. It may have been a trialogue between the courts, academia, and the medical profession. You're nodding, so that's very reassuring. I was able to follow after all. So that's interesting to me. I think, and it's also probably interesting to those present. So they're not all students then, of course, Solvita's not. But indeed, this is an international seminar, it turns out, so this is great. But the idea that there's some sort of trialogue, or maybe sometimes a dialogue, or something else, multi-party, a conversation between the courts, the law, one might say, in other words, and others, it might seem somewhat unusual to students. But anyway, I suppose that's more of a comment. I'll try and formulate a question.
Okay. Let me respond, Mark, while you think about it. So what I've just presented is a very early cut of a chapter in a book I'm working on at the moment, which is tentatively titled The Making and Remaking of Medical Healthcare Law. And the hypothesis that I've reached, having reflected on what's gone on sort of since what appeared to be a sort of deferential constitutional settlement in the end of the 70s through the 80s and the early 90s, to a more rights-based one now. What I've come to understand is that actually there is a whole series of conversations going on in that process, and that the hypothesis is that the only real way of explaining how the law has changed is to try and uncover those conversations, which come to the surface sometimes in court decisions, but actually are going on without them. So some of those conversations are, as we described here, sort of trilateral. So there's a set of judicial decisions, there's a development of a literature within medical ethics, and there's a development of a literature within the academy. But there are other versions. There are spats between judges. So if you look at the law in relation to the interpretation of the best interests decision, you have a very clear conflict between James Mumby arguing that we want a more legalistic view of best interests, and arguing that in withdrawal of treatment cases, the keystone of best interest is intolerability. So you should always give people a chance of life, unless that existence would be intolerable. And other judges arguing that the statutory test is best interest. So there's a conversation within the judiciary there, and you can actually trace that through in judgments where they talk to each other. You can also see in relation to capacity to consent and concurrent consent from young people that there's a conversation between the judiciary and the academy, and the judiciary don't like the criticisms that the academy have made of them. So Lord Donaldson in the 1990s, more recently James Mumby, have said some quite rude things about academics not really knowing what they're doing. And you can see how the legal doctrine is partially developed in order to answer voices in those conversations. And then, of course, you have cases such as you see in relation to end-of-life care or in relation to abortion, where there are conflicts being played out in the courts, but they're conflicts that don't start in the courts. So you have test cases, you have not just cases about individual disputes, but you have cases about guidance that's being issued. So actually, I think this is quite a normal process. If we only read the court judgments and we try and extract using the skills that we learned about precedent, statutory interpretation, we're only scratching the surface of what is really driving the doctrine. So that's my sort of working hypothesis for quite a wide-ranging piece of work. So I think that was pretty smart for you, Mark, to spot that going on, because that is absolutely what I think is happening.
Thank you. Well, I should just say that I'm familiar with the idea of dialogues and trilogues and conversations in other areas of law, especially, so part of my background is as an EU lawyer. And anyway, I don't want to go down that route, but there's something interesting here, and in the absence of questions in the chat, I'll just continue. Something really interesting.
Can I fly a kite then, Mark, if no one wants to come in? So I've tentatively reached the conclusion that the big anxiety that we have had about Boehlemization, this idea that we've handed over to the medical profession the standard of care in our law, which Lord Scarman articulated around Sidaway when they rejected his view, and which lies behind why lots of people seem to be very keen on the Montgomery decision. I think that sense that we did that in the law is almost certainly an invention of the academy. I don't think the cases justify it. The textbooks link together decisions that actually are quite different, and they make them add up to something. And I think that could only happen because people like me were trying to design courses and write textbooks, and we needed therefore to give some shape to the law. So I think quite a lot of our doctrines that we grapple with in medical law turn out to be a product of the way in which law schools change and a new subject was created. And I'm very happy to come back another time and try and defend that at length. But
that would be great.
I'm really surprised by that intuition, and I'm trying to work through whether the intuition is well founded or not. But the more I do, the more I think it's true, and therefore you can't understand the subject only by reading the legal judgments.
Right, absolutely. I've got. I'm just looking at the clock, and it says we've got about 7 minutes left. What I suppose, just to take things one step further, if I may, or try to. I don't know if you've thought about these sorts of things, but if there is, say, a trialogue, so 3 constituencies or parties to a conversation in particular. I suppose I've got 2 key, or one's perhaps a comment, and then there might be a question. The first is just wondering if there's a difference in the underpinning epistemologies, right, of each of those parties to the conversation. There might not be, they might be broadly aligned or similar. But I wonder if you've given any thought of that, because there are pretty different bodies of knowledge. I would suggest, or at least perhaps there could be. So that's the first thing. So just thinking in terms of that, because that would seem significant in the conversation and for the progress of how doctrine turns out. But then the second thing is, I'm wondering, I suppose they're really linked. The second thing is, I suppose, have you given any thoughts? And I don't mean to take you too far away from today's talk, by the way, but I'm just really interested in what you've been saying on this point of conversation. But have you given any thought, then, this is my second point, about an underpinning theory to explain the trialogue, the conversation, the dynamics, how the conversation goes, something like that? I'm just interested.
Okay, so these are deep and complicated questions with long words.
Sorry.
So starting with the epistemology sort of question. So the question there, I think the essence of it is what do we think counts as a good argument or a truth? Some we could say as being true in an area. And the accusation I made around us not having done our sort of legal method work properly around precedent and the like, it is a version of, there's an epistemology around law that says that there are ways in which legal knowledge works. And I guess, my first observation would be that, we say we behave like that, but we don't actually do it in our legal analysis, and that needs exploring and unpacking. Now, whether that means that what we're dealing with is competing epistemologies, so what we're dealing with is alternative ways of working out what the right thing is, and we're having to choose between them. I think we do that. So I did some analysis of the Charlie Gard case. So Charlie Gard was the boy in Great Ormond Street whose parents wanted him to be treated with experimental therapy, and Great Ormond Street thought it was inappropriate, and they took it to court. And I argued in the analysis of that we had at least sort of 3 different types of claim going on. So one type of claim was about the chances of success and what the likely course of Charlie's illness was. And I said, we would usually think that was a scientific type claim, and therefore the criteria against which you judged it should be based on scientific method, and then we would ask ourselves, who are the guardians, if you like, of that method? And that would tend to take us to a medical sort of standard on those questions. So will the treatment work? What will happen if we don't do it? Charlie, seems like it's a medical type question and reasonable to go to experts on medicine. Then there's a second issue, which is about risk appetite. So how much risk are you prepared to take? And for an adult, we would say the only person who can take that risk is the patient. So that's what drives the sort of informed consent patient-centered disclosure standards, is that once the possibilities are known, well, it becomes inappropriate to have a generic standard for whether a risk is worth taking, because that can only really be judged by the person taking that risk. And then there's a third set of values at stake, I thought, in the Guard case, which was around how we as a society value life, we value disability and the like. And that seems to me it would be inappropriate to say that that was for medicine to decide, or indeed an individual family, like Charlie Guard's family, to decide. And we would expect some sort of democratic legitimacy for that. So I'm appealing, if you like, to a different owner of the epistemology in those areas. And you could extrapolate that in other sorts of ways. The underlying theory, I think, is much trickier. But at the moment, I think I'm minded to think that the theory of law is probably something like that developed by Scott Shapiro around it's a plan. The law needs to organize an infrastructure so that we can take decisions, sometimes interacting with each other. And so the type of rule of law requirements that come from that would roll out of its ability to help us plan without dictating the particular values that we impose. So I've almost run out of time now, Mark, but that's where my thinking has got me to.
Thank you. I got a lot out of that. So, and it's going to provide me with much food for thought in my own work. And of course, that's one of the I suppose the points of having a seminar. It's to focus on the specifics, but then also see if there's resonance with other people's interests, and other people such as me can learn something and that we can take forward. So thank you so much, Jonathan, for your responses to the questions and the comments. I'm going to conclude now, everyone, and I'm going to do that in the following way. I'm going to begin by saying thanks very much to all of you, the audience, for signing up and attending today. If you're not present and you're listening to this recording, that's as a student at the School of Law at Queen's, thank you for listening. As we've said, it's important that you do engage with a wide body of literature, a wide range of authors, and Jonathan is amongst those we direct you towards. And so we're honoured and privileged then again to have Jonathan with us today. I want to thank, before finally saying thank you, a big thank you again to Jonathan, I want to thank Declan Coyle very much for all the work that he does behind the scenes. We wouldn't be able to put this seminar series together, to convene it, to make sure it actually goes ahead okay without his help. And I'm really grateful to him, particularly today, given that I've had some technical difficulties which don't seem to be getting better, but we'll see. Maybe tomorrow things will be better. But anyway, back to our speaker. So Jonathan, thanks very much again for your time. It sounds like it's a very busy day. I guess they're all very busy days, but thank you so much for taking time out of your very busy day to speak to us, to share your thoughts, which are very much at the forefront of discussion in medical law. But I do think, especially towards the end there, in your responses, do have very wide resonance across legal studies, and probably amongst those interested in socio-legal studies as well. So thank you so much for that, and I'm really looking forward to reading your work when it comes out, of course, and hopefully just being mindful of an email conversation I've had with you over the last few months. Hopefully we'll get a chance to work together. We'll see. It should be progressing, but I will email about that in due course. But with that, I'll say thanks again to Jonathan and to all of you, and I wish you all a very good afternoon.